Good afternoon. I'm Dan DeRose with 19 News, coming to you from our digital desk. We want to continue the conversation in the topic of justice for Julian. Today, we saw the defendant in court, Bianca Ellis, in a very strange situation for an arraignment. At first, it was via video. She wouldn't answer the judge's questions. She then was brought into the courtroom. And at first, she started to whisper her answers to the judge. She then, when the judge asked, is it correct that you want to plead not guilty? She said, sí, as in Spanish, as in saying yes. The judge had to ask her, of course, this is an official court case. Does that mean yes? And she did finally say yes. This is, of course, in relation to the death of little Julian Wood. Just 1 week ago, within a couple of hours, was stabbed and killed in the Giant Eagle parking lot while he was with his mother. He was in the shopping cart. His mother, Margot, was also stabbed. And then again, you had the suspect, the defendant, get arrested within just a few yards of the actual crime. There was a lot of talk in court today, mention made by her representing attorney that she does suffer from mental health issues. We also learned today for the first time the prosecution, the state, intends to make this a death penalty case, that it's potentially now going to end up in a death sentence if she is found guilty. Obviously innocent until proven guilty, but that's why we have the court system. Speaking of, we're going to bring in Michael Benza. He is a professor of practice at Case Western University School of Law. Professor, thank you for joining us today. How are you?
I'm just fine, thank you.
Obviously, you are not connected with this case. We are just using you as an expert. You have the legal background that we do not to be able to understand what goes forward. There's two issues we really want to talk about, this mental health issue and then the death penalty issue. Let's start with mental health. This appears to be someone, her strange behavior in court today, obviously the strange behavior of stealing a knife and stabbing a 3-year-old in the parking lot, that goes without saying. But if there was a defense of not guilty by reason of insanity, of course she pleaded not guilty today. Where does that come up? When would she plead not guilty by reason of insanity, and what happens after that?
So we're at the very beginning process of this case. So there's still a fair amount of work that will have to be done before the issue of a not guilty by reason of insanity plea would be entered. If this is going to be a capital case, for example, there need to be the appointment of 2 capital qualified attorneys. They will have to do their investigation, and then they will bring the issue of a change in plea to not guilty by reason of insanity, probably several months down the road.
And let's talk about what that means. And you're the expert here, but I've covered enough court in my career that there's a very big difference of having a mental health issue and being clinically insane, to where you didn't know what you were doing, you didn't know where you were at. What is the big difference when it comes to pleading guilty by reason of insanity? What is sort of the hook?
So it's actually sort of 2 parts of the test. You have to suffer from what the law calls a mental disease or defect. So you have to have a mental health condition or some other medical condition like mental retardation, intellectual disability, something like that. But then there's the relationship between your mental health status and your conduct at the time of the crime. And so Ohio has adopted what's called the McNaughton rule, which is that the person, because of this mental disease, is incapable of understanding the rationality of their conduct or unable to conform to the law. That's the hard part of the burden. Unfortunately, we have a fair number of people who come through the criminal justice system with mental health problems that do not rise to the level of competency or not guilty by reason of insanity.
And I think that's the big part of this that we need to sort of hammer out, is that idea of understanding that what you did at the time had consequences. And that's That's really when they, obviously, when someone tries to take that route of pleading guilty by reason of insanity, there have to be doctors that brought in, psychologists, psychiatrists that get brought in to give this examination. And it's a big part of that examination is what? What are they trying to get to the bottom of?
What they will focus on in the evaluations, one clinically is reaching a diagnosis of does this person actually suffer from the mental health disorder? It sometimes helps, but it's not critical to have a specific diagnosis. It's that second part of trying to do the relationship between the mental health disorder and their understanding of what it was that they were doing at the time that they committed the acts that they are charged with. So it's really difficult for psychologists, psychiatrists to try to go back and see what this person was thinking, because it's not that you know that you're killing somebody, for example, but it's rational understanding that what you're doing is wrong. All right. So if you have, for example, a delusion that tells you this person is an alien, then the issue is you don't know the wrongfulness of your act, because while everybody else sees you killing a person, your mental disorder is telling you you're killing an alien. Those are the difficult nuances of the evaluations that become critical in this kind of a case.
You brought up the question, did you know what you were doing? Wouldn't, and I'm just being devil's advocate here, and if you don't feel comfortable going in this direction, that's understandable. It would seem to me that someone who was just at the police department, she was asking the police for money that she thought they had taken from her a few days earlier. She finds out they don't have her money. She immediately walks across the parking lot into Volunteers of America. She steals 2 knives. And then basically hunts or scouts out her 2 victims. Don't all of those things lead to knowing what you're doing? You don't walk into Volunteers of America to steal a knife if you don't have the intention of killing someone.
Right, but that's where the mental health issue of not guilty by reason of insanity comes into this discussion between the legal issues and the medical professionals. Because it's not that you could plan your conduct, take action to accomplishing a goal that in and of itself says yes or no regarding a not guilty by reason of insanity. It's the person's cognitive ability to understand that what they are doing is in fact wrongful conduct. That is, they can appreciate not that they're doing it, but that what they're doing is wrong. That's where the nuances of mental health discussions come in.
It is obviously a high-profile case at this point. Headlines across not just Ohio, but the country, even going international. We are speaking with Michael Benza. He is a professor of practice at Case Western Reserve University School of Law. Let's move on to the second part of this conversation. We found out today the prosecution has turned this into a capital murder case, meaning they will be seeking the death penalty against Bianca Ellis. Let's talk about, and a lot of people have a hard time understanding the nuances of a death penalty case. As you said, right away, you get 2 attorneys instead of your 1 that both have to be versed in capital murder cases. But what is the difficulty for the state when it comes to proving whether this was just murder or whether this was aggravated murder with a death penalty specification? Why is that death penalty so difficult to obtain?
Well, one of the reasons that death penalty cases are so difficult, both to prosecute and to defend, but then also to get to the resolution of life versus death, is we've built in so many different types of protection. So first off, it has to be a very special kind of murder case. And so you have to demonstrate not only that the person had purpose to kill, but that formed this prior calculation and design, which is a higher mental status about what they wanted to do in actually committing the killing. But then you have to have the aggravating factors. My guess would be the prosecutors are probably looking at least 2 aggravating factors. One would be that the victim, Julian, is under the age of 13, which in and of itself is an aggravating circumstance. It could also be the course of conduct specification, that is an attempt or actual killing of two or more people. There may be an allegation that there was also a robbery involved in this. So those would be the things that make this eligible for the death penalty if the prosecutor can prove those things. On the other side will be the issue of, well, what is the appropriate sentence? And even if not guilty by reason of insanity does not result in that finding and then for take the death penalty off, we know that juries are most focused on issues of mental health. Also related to that is that Ohio has a relatively new statute that prohibits the execution of people who suffer from one of four special mental health disorders, and that disorder had an impact on their conduct during the crime. It's not guilty by reason of insanity. It's a different legal standard. And so that will also be a focus of the litigation is she actually ineligible for the death penalty because of her mental health condition?
And those are all incredible points. Didn't know that new statute, so we appreciate giving us the insight on that. I want to go back to this death penalty with prior calculation, and that is in some instances why you will see a murder or a homicide conviction as opposed to a death penalty case. Explain to us why that prior calculation. What does that mean? Does that mean that I didn't like my spouse or my ex, and so I planned out this whole thing and I went and bought the gun? But wouldn't that sort of pertain here? She went and she got that knife, but yet she didn't know the victim. So that prior calculation is important here.
That's right. And it does really relate to, did the person do some degree of planning prior to carrying out the underlying homicide? And it's not just that you sort of went out with the idea of killing this person, but you actually formed this plan. In other states, you might think of it as sort of premeditation, that you are doing this thinking and calculating ahead of time about what you're going to do. How much time becomes a legal issue? How much time do you actually have to think about it before you do or don't reach this prior calculation and design?
And we won't get the answer to that. She may know it in her head that when she left the police department, I'm going to go do this, and that's sort of calculating a plan. But we won't get the answer to that, correct? Because she doesn't have to say.
Right. She does not have to say what it was that she was thinking. The burden is always on the prosecution to prove the allegations. Now, the prosecutor would always like to have the defendant to make a statement and to explain exactly what was going on. But that's not often the case. And so the prosecutors will try to show this story of what her conduct was, and then that equals prior calculation and design. Defense will do the same thing, use the same facts, use this, witnesses, their witnesses to try to tell a different story, maybe even on the fact that she was not capable of engaging in that kind of thought process.
It is going to be an interesting case to watch because it does have so many nuances and so many facets of mental health and of the death penalty specification. Professor Benza from Case Western University School of Law, we certainly appreciate the time and your expertise. Thanks for joining us today.
Happy to be here.
All right, take care. We're going to wrap this up. Again, just a discussion that many around Northeast Ohio are having. How could this happen? And now the next step in this process. Where does it go from here? We're going to follow this as we have throughout the entire incident and the accident and the tragedy, all the way through the funeral this weekend of little Julian. And now that we've entered into sort of the court section of this, we're going to have it every step of the way. Watch for 3.5 hours of news, including updates on what was said in court today. Very hard moments for Jared Wood. That is the father of Julian. He spoke today in court to the judge, calling the defendant a monster. And you'll see that when we start our news at 3 o'clock. Until then, I'm Dan DeRose with 19 News. Have a good afternoon.
19 News is everywhere. Download